Welcome back to Exhibit A-List, the courtroom of public opinion, where pop culture is chaos, the law is messier, and we don't pretend otherwise. If you're new here, welcome. If you're returning, congrats. You've officially become someone who understands the legal system better than at least half of the internet. That's great. Grab your iced coffee, silence the group chat, and let's get into it because today's docket is stacked. We've got scam queens, influencer explosions, corporate theme park fraud, superhero copyright drama, and in case you needed proof that society is cracked, people are sending cease and desists over baby names. So let's begin. All right, let's start with Salt Lake City because Bravo cannot write a storyline that competes with federal sentencing reform, Shah. If you watched even 5 minutes of Real Housewives of Salt Lake City, you know exactly who I'm talking about. If not, imagine an avalanche in a designer coat. That's Jen Shah. She pled guilty to one of the largest telemarketing schemes we've ever seen come out of reality TV. It's actually one of the largest I've ever heard of, targeting elderly and vulnerable victims across the country, promising business services that didn't exist and draining their life savings. We're talking about a $6.5 million in restitution and a 78-month sentence. And here's where federal law gets federal. She's now walking out on December 10th after barely 30. Now, people hear that and assume that celebrity clause kicked in. Like the Bureau of Prisons has a housewife exception, which at this point, with the amount of crimes the housewives commit, they might need to get one. But no, they don't. What they do have is something almost no one pays attention to until they're facing time. There's things like good time credits, First Step Act program credits, rehabilitation classes. So these are things that people can do to get out early. The very real incentive of behave or stay longer. And Jen Shah, she apparently behaved. She's a smart girl. We know that at least. And the system rewards that. But let me be clear, early release doesn't mean clean slate. She still owes millions. And let's best believe she's got to pay that back. She still has supervised release. And every check she cashes from a book, a docuseries, we know she's going to be producing lots of stuff after this time in prison. She might even have a candle line called Shah Amazing Redemption. Whatever she cooks up, the feds can take that and pay the victims, as they should. And that's where the case hits differently, because while Jen gets a redemption arc, the victims don't. They're not getting their money back. They're not getting closure. What they're getting is the same woman the U.S. attorney once called a leader of the scheme, walking out 45 months early. So the big question now is, does Jen reinvent herself as the humbled, cautionary tale, or is she already drafting the pitch deck for her comeback special? Honestly, the federal government might want their cut of that production too. All right. Well, let's pivot from federal prison to influencer implosion, because the next case is peak 2025 internet. Stefon Diggs versus a viral accusation. What happens when allegations become content? This is the Stefon Diggs versus Griffith situation. The most Instagram meets legal liability story we've had in months. Here's the quick setup. We've got Griffith, a stylist and influencer, and he posted allegations on Instagram involving serious things: sexual battery, drugging, coordinating a violent assault, tagged brands, celebrities, PR reps all along the way. And we're not talking like a vague story time. We're talking very specific accusations packaged for virality. Diggs immediately denied everything, and then he hit back. He filed a libel lawsuit alleging fabrication, theft, and a false police report. Let me break down the legal reality because it's so often missed. Sexual battery claims in civil court are not criminal. Let's just get that on the table. We think because it is a crime that when it's alleged in a civil case that we're talking about criminal action, but they're two different cases. So right now, if there's a civil lawsuit, no one's going to jail based on a lawsuit. Civil sexual battery is about damages, and the standard is more likely than not, versus when you're in criminal court, it's beyond a reasonable doubt. Now, Diggs is a public figure. That changes the entire defamation landscape. So to win in this libel case, he's got to prove actual malice. That means that the statements were false and that they were specifically made with reckless disregard of the truth. That's a high bar. It's not impossible, but it's not a casual lawsuit. The influencer era, though, has created a brand new kind of evidence because with influencers basically documenting their entire life, they've got screenshots, stories, highlights. They create the timeline on their timeline. They're tagging brands, there's DMs, and all of that becomes discovery material. We now live in a world where a viral story isn't just content. It's potential court evidence. This isn't just a he said, she said. It's a case about what happens when accusations live online, spread online, monetize online, and then land in a courtroom that moves at a completely different pace. And honestly, this case is going to set the tone for a lot of influencer-driven allegations moving forward. All right, let's leave the influencer court right now and head straight into Wall Street because our next story is unintentionally funny. You know how theme parks look fun on the outside, and behind the scenes, it's all rusty metal, overheated compressors, and someone duct taping a sign that says ride closed. Welcome to the Six Flags lawsuit. Six Flags and Cedar Fair sold Wall Street a transformational merger complete with a new ticker symbol, FUN. And after the merger, the financials dropped faster than a roller coaster. Shareholders are now suing, claiming that the registration statement, which is the document that investors rely on, allegedly hid years of underinvestment, massive maintenance backlogs, and capital needs that were not insignificant. Here's the legal tea. In securities law, if you don't get to forget the ugly details. If a company knows something material that could affect investors, they have to disclose it. If they downplay it, gloss over it, pretend every ride is shiny and safe when they know the drop tower needs $20 million in repairs, that's how you wander into securities fraud. This lawsuit is going to come down to, did the executives knowingly oversell, or were they just aggressively optimistic? Either way, the irony of using fun as a ticker while shareholders file fraud claims, the jokes write themselves. It's time to literally fly to Hollywood for our next story, the Superman ownership battle, because apparently even superheroes have legal issues. This is a fight between Warner Brothers and DC, the estate of Joe Shuster, one of Superman's co-creators. The estate says that under an international copyright laws in places like UK, Canada, Australia, certain rights should revert back to them 25 years after Schuster's death. Warner Bros. Say absolutely not, pointing to a 1992 agreement where Schuster's siblings sold all rights in exchange for around $25,000 a year forever. A federal judge in New York sided with Warner Bros. But the estate has already refiled in state court using different legal angles and a different copyright regime. This case matters because characters don't die and copyright law is messy. Contracts from the 90s can come back to haunt major studios, and big budget releases depend on who owns what the exact moment that the movie is ready to hit the theaters. This is one of those cases where Hollywood actually is going to watch, because if Superman can be pulled back into an ownership limbo, then really anything can. And okay, deep breath, because our final story is about cease and desist. I recently was listening to a podcast and they were discussing someone receiving a cease and desist over a baby name. And I was like, we need to talk about cease and desist because these are flying. And maybe people just don't understand how they work. People are now trying to send a cease and desist to stop other people from using a baby name. Let me make something extremely clear. A cease and desist is not a magic scroll from a wizard. Anyone can send one, but is it worth more than the paper it's written on? You can write one in crayon on a napkin and technically it's a cease and desist. But unless you have a legal claim that is valid, something grounded in let's say trademark, copyright, defamation, harassment, a baby name cease and desist is nothing. So here's when a cease and desist actually applies. You have a registered trademark. Someone is misusing your name to confuse consumers. There's harassment or real threats. Someone is commercially exploiting your likeness. But here's when it won't apply. You call dibs, your sister-in-law stole your favorite baby name, you're bored, you're petty, you think legal stationery makes you look important. The only thing sending a cease and desist over a baby name guarantees is that the entire family will talk about you for years, and not in a flattering way. All right, that's it for today's docket. It was short, it was spicy, it was informative. Scam queens are thriving, influencer lawsuits are escalating, roller coasters are causing securities fraud, superheroes are stuck in copyright hell, and grown adults are weaponizing cease and desists over baby names. If you made it this far, you are now officially someone who understands the legal system better than the people screaming in your comment section. If you learned something, hit follow, leave a review, send this to the friend who's always thinking that they found a legal loophole in the terms of service. Find me on Instagram and TikTok. Instagram, I'm at Jasmine Weg, ESQ, and also Exhibit A List Pod. TikTok, I'm at Jazz the Lawyer. Tell me what cases you want to learn about next, especially if it's messy. And remember, stay curious, stay sharp, never end up as Exhibit A. Court is adjourned.